Welcome to our webinar regarding the newly proposed Department of Labor Fiduciary Rule. This presentation will last about 45 minutes, and a recording will be available on the Wagner Law Group website, www.wagnerlawgroup.com. You can access previous webinars on the website as well. Let me introduce our presenter, Marcia Wagner. Marcia is a specialist in pension and employee benefits law and is a principal at the Wagner Law Group, one of the nation's largest boutique law firms specializing in ERISA, employee benefits, and executive compensation. She founded the law firm in 1996. A summa cum laude and Phi Beta Kappa graduate of Cornell University and graduate of Harvard Law School, Marcia has practiced law for over 28 years and is recognized as an expert in a variety of employee benefit issues and executive compensation matters, including qualified and non-qualified retirement plans, and all forms of deferred compensation and welfare benefit arrangements. Marcia was appointed to the IRS Tax-Exempt and Government Entities Advisory Committee and ended her 3-year term as the chair of its Employee Benefits Subcommittee and received the IRS's Commissioner's Award. She has also been inducted as a Fellow of the American College of Employee Benefits Council. For the past 7 years, 401k Wire has listed Marcia as one of its 100 most influential people in the 401k industry. She has received the Top Women of Law Award in Massachusetts and is listed among the top 25 attorneys in New England by the Boston Business Journal. She has written hundreds of articles and 18 books about retirement and benefit plans. She is widely quoted in business publications such as the Wall Street Journal, Financial Times, Pension Investments, as well as many others. And she has been a frequent guest on Fox Business, CNN, Bloomberg, NBC, and other televised media outlets. Welcome, Marcia.
Thank you very much. Good afternoon, and welcome everybody to today's webinar. We will be covering the DOL's new fiduciary proposal, which has been called a potential game changer for the entire retirement industry. People are still trying to digest all of its implications, but it is clear that this proposal is going to be one of the most significant and groundbreaking pieces of rulemaking ever to emerge from the Department of Labor. The DOL proposal is designed to broaden the scope of retirement advisors who are deemed to be fiduciaries under ERISA, and it also is designed to address their potential conflicts of interest when advising their retirement clients. The scope of the proposal is far-reaching, and it specifically covers and protects IRA clients as well as plan sponsors and participants. As a formal matter, the proposal includes a new regulation defining what fiduciary investment advice is, as well as 2 new class exemptions for prohibited transactions and significant amendments to the number of existing class exemptions today. What I would like to do is to first put out the proposal in context by discussing the existing rule, and then navigate through the proposed fiduciary definition, the carve-outs from the definition, the applicable exemptions, and the expected timeline for this DOL rulemaking project. So, let's begin. The original definition of a fiduciary was established by the Department of Labor in 1975, just after ERISA was enacted. Of course, 40 years ago, when the original fiduciary rule was established, the retirement industry looked very different. As a corollary, I would also like to point out that the Investment Advisors Act, the Securities Exchange Act, and the rules of self-regulatory bodies such as FINRA were also based on the common practices of the day. Registered investment advisors, or RIAs, provided investment advice for an asset-based fee, and broker-dealers effected securities transactions for a commission. Back then, it was quite easy to distinguish advisory versus brokerage activities, and brokers generally took the position that they were not rendering fiduciary advice. Now, in 2010, the Department of Labor issued a proposed regulation, as I am sure many of you remember. It expanded the fiduciary definition considerably and it would have impacted many advisors who do not currently view themselves as fiduciaries. Following a vigorous industry debate, joined by Congress and the executive branch, the Department of Labor decided to withdraw the proposed regulation and reassess its position. Now, almost 5 years later, the department has issued a new proposal for the definition of a fiduciary under ERISA. As we'll discuss, it represents a significant regulatory push toward a universal fiduciary standard for all types of retirement advisors. If you are deemed to be providing investment advice relating to plan assets for a fee or other compensation, you are deemed to be a fiduciary and subject to a high standard of care under ERISA. The existing DOL definition has a 5-pronged test in order to be deemed a fiduciary providing investment advice. The advisor needs to make recommendation as to investing in securities or other property, or give advice as to their value on a regular basis. There must also be a mutual understanding that the advice will serve as a primary basis for the plan's investment decisions, and the advice must be individualized to the particular needs of the plan. The DOL position is that this definition is too narrow in today's world, allowing many advisors to effectively provide advice without having to answer to the fiduciary standard of care under ERISA. For example, an advisor could take the position that its advice is not provided on a regular basis, or that there is no mutual understanding that the advisor's recommendations will serve as the primary basis for the plan's decisions. Because the 5-pronged definition is so narrow, the DOL believes that it was too easy for advisors to escape fiduciary status. Therefore, the DOL is now seeking to expand the definition considerably to include a much broader group of advisors. As with the existing fiduciary rule, under the DOL proposal, a person who provides investment advice for compensation would still be viewed as a fiduciary. For purposes of the proposal, the DOL has clarified that a person can become a fiduciary by providing investment advice to plan fiduciaries, which of course would include plan sponsors, participants, IRAs, and IRA owners. The regulators have always taken the position that fiduciary advice covers advice to plan sponsors, participants, and IRAs. Accordingly, this proposed clarification memorializes the DOL's position as reflected in various rules and releases. However, under the new DOL proposal, the definition of investment advice has been broadened considerably. As proposed, there is a 4-pronged definition. You are providing investment advice if you are making the types of recommendations that are covered by the rule, which we will be discussing shortly. And there merely needs to be an understanding that the advice will either be individualized or specifically directed to the recipient for consideration by the recipient in making investment decisions for the applicable plan or IRA. There is no longer a need for there to be a mutual understanding between the parties that the advice will serve as a primary basis for plan decisions. Under the existing definition, investment advice only covers recommendations relating to investments and their value. But under the new DOL proposal, it broadly covers 4 different categories of recommendation. First, as with the existing rule, it covers recommendations relating to investments in securities or other property. But the DOL has clarified that it will also cover recommendations to take rollovers from a plan as well as investment recommendations for rollover assets. Second, the proposed definition also includes recommendations relating to the investment management of the assets of the plan or IRA, including rollover assets. In other words, recommending an investment manager will also count as covered advice. Third, giving financial valuations, appraisals, and fairness opinions for any investment held by a plan or IRA will also be viewed as a covered recommendation. And lastly, recommending a person who provides any of the above three services for compensation will also be considered covered advice. For example, a person who recommends an advisor who in turn recommends investments or investment managers or provides appraisals would be an investment advice fiduciary under the newly proposed four-pronged test from the Department of Labor. The DOL proposal provides an alternative way in which an advisor may be deemed to be a fiduciary providing investment advice. Specifically, if the advisor makes covered recommendations, such as an investment or investment management recommendations, the advisor will automatically be deemed a fiduciary if it represents or acknowledges that it is serving as a fiduciary with respect to the advice that it's providing to the plan or IRA. The representation or the acknowledgement does not need to be in writing. Therefore, it appears that if an advisor were to verbally hold itself out as a fiduciary, this may be sufficient to convert the advisor into a fiduciary. The potentiality, as I'm sure you see, for a he said, she said, is therefore great. I just want to highlight that a representation or acknowledgement is all you need to trigger fiduciary status. Even if the advisor does not, therefore, meet the four-pronged definition, he or she will be deemed to be a fiduciary with respect to the applicable plan or IRA. For example, if an advisor were to publish an investment newsletter stating that it contained fiduciary advice, the advisor may be deemed to be a fiduciary to those readers with IRA accounts, even though the newsletter advice is not individualized or specifically directed to any particular IRA client. I just want to take a minute to share a few observations about the DOL's proposed investment advice definition. The proposal really does broaden the scope of what fiduciary advice is. So even one-time advice that is not provided on a regular basis could potentially be viewed as fiduciary advice. As mentioned before, there is no need for a mutual understanding between the parties for fiduciary advice to be provided. It is enough for a plan or IRA client to unilaterally think that the advisor is providing fiduciary advice to trigger fiduciary status. The advice does not need to be individualized or particularized. The advice only needs to be specifically directed to the retirement client. Also, the advice no longer needs to serve as the primary basis for the retirement client's investment decision. So long as the client merely considers the advice when making its decision on behalf of the plan or IRA, that is sufficient. Lastly, I just want to note that the existing definition clearly covered investment recommendations, but it omitted investment management recommendation. Because of the literal wording, certain advisors took the position that recommending investment managers as opposed to investments was not a fiduciary act. However, some DOL officials had taken the position that investment management recommendations are also considered advice, and the DOL proposal is now formalizing this point of view. In recognition of the broad scope of the proposed fiduciary rule and the investment advice definition, the DOL proposal includes 6 carve-outs from the fiduciary definition. So long as you fall under one of these 6 categories, you will not be deemed a fiduciary, even when providing investment-related recommendations to retirement clients. Of course, a person or a firm will not be eligible for exclusion from the investment advice definition if they represent or acknowledge that they are acting as a fiduciary when advising any plan or IRA client. So let's briefly look at the 6 carve-outs. Under the DOL proposal, if a person is acting as a counterparty in an arm's-length transaction with a plan, the counterparty may provide advice without being deemed an investment advice fiduciary by complying with certain conditions. For example, if a broker-dealer were to sell a financial product from its inventory to a retirement client, the broker-dealer would be a counterparty to the client, and it would be permitted to provide related advice without being deemed a fiduciary by complying with the requirements of the carve-out. In order to so comply, the plan sponsor or the fiduciary generally must provide written representation that the plan has at least 100 participants, that it has sufficient expertise to evaluate the transaction, and that it will not rely on the counterparty to act as a fiduciary. The written representation is not required if the plan fiduciary has at least $100 million of assets under management. Moreover, the counterparty must fairly inform the plan fiduciary of the nature of the counterparty's role in the transaction. Finally, no direct fee may be paid to the counterparty from the plan or the plan fiduciary in connection with the transaction. It should be noted that this carve-out does not apply to agency services, such as a broker's providing fund recommendation for 12b1 fees. Swaps are derivative transactions, and many institutional plans, particularly but not exclusively larger defined benefit pension plans, utilize swaps on a routine basis these days. For example, a plan in a bank might enter into an equity swap where the parties exchange the future cash flow values of 2 hypothetical investments, one linked to an equity investment like S&P 500 and the other linked to a floating interest rate such as LIBOR. The carve-out from the proposed investment advice definition for swap counterparties covers any related advice provided by the swap dealers and major swap participants when engaging in transactions with the plan. A third carve-out is with respect to employees of a plan sponsor who will not be deemed to be fiduciaries with respect to any advice given to the plan sponsor or any other plan fiduciary relating to the plan and its investments. This is a fairly straightforward carve-out. To qualify for this relief, the employee must not receive any additional compensation like a bonus for providing such advice beyond the employee's normal compensation. This carve-out is designed to protect internal employees, such as HR professionals, who would otherwise be exposed to potential fiduciary liability when offering investment recommendations and similar assistance to the plan sponsor. That this carve-out is even necessary shows how broad indeed the definition of an investment advice fiduciary could be. The carve-out for platform providers is interesting. This carve-out from the proposed fiduciary rule applies to providers of investment platforms for defined contribution plans with participant-directed investments. For example, this carve-out is designed to provide relief to 401k record-keeping platforms. As long as the applicable conditions are met, the platform provider would be able to offer and market various investment funds from its platform, which in turn may be offered as investment alternatives to participants under the plan. The provider would need to make these investments without regard to the individualized needs of the particular plan or its participants. The provider would also need to disclose in writing that it is not undertaking to provide impartial investment advice or to give advice in a fiduciary capacity. Under the proposed carve-out, the platform provider would be permitted to identify investment alternatives meeting objective criteria specified by the plan fiduciary, such as investment funds of a certain size or with expense ratios beneath a certain threshold level. The provider would also be permitted to provide objective financial data for investment alternatives as well as benchmark comparisons. Under the DOL proposal, providers of financial valuations, appraisals, and fairness opinions for investments held by plans or IRAs may be viewed as investment advice fiduciaries. However, there's a carve-out or an exclusion for valuations and appraisals that are provided on behalf of ESOPs. Similarly, there's an exclusion for valuations and appraisals for pooled investment vehicles, including SIFs or bank collective investment funds. Valuations and appraisals that are provided for certain regulatory reporting purposes are also carved out. This carve-out applies to covered valuations and appraisals that are delivered to plan sponsors, to participants, and to IRA owners. Lastly, but certainly not least, is the carve-out from the proposed fiduciary advice rule for investment education. The proposed carve-out is based on the existing safe harbor for non-fiduciary investment education under Department of Labor Interpretive Bulletin 96-1. Consistent with the current safe harbor, there are 4 categories of investment-related guidance that may be provided to retirement clients without triggering fiduciary status. They include plan information, general financial investment and retirement information, asset allocation models, and interactive investment materials such as retirement calculators and questionnaires. It should also be noted that while the existing safe harbor only covers participant education, the proposed carve-out applies to investment education delivered to plan sponsors and IRA owners as well as to participants. The carve-out also expands the scope of non-fiduciary education by also covering guidance for assessing retirement income needs and strategies for managing assets in retirement. The DOL proposal also makes it clear that in order to qualify for the carve-out, the investment education must not recommend any specific investment product. Under the existing safe harbor, asset allocation models and interactive investment materials may reference specific investment alternatives available under a plan, so long as certain disclaimers are included with these materials. However, under the proposed carve-out, in no event may educational materials make any reference to a specific investment alternative. Now, because of the broad scope of the proposed fiduciary rule, the DOL recognized that exemptive relief would be necessary for those advisors who do not currently hold themselves out as fiduciaries. For this reason, the Department of Labor has simultaneously released 2 new exemptions and has amended several existing exemptions. But let me back up and talk about exemptions in general. Under Section 406B of ERISA, there are prohibited transaction rules that prevent a fiduciary from providing any conflicted advice that would increase its own compensation. There are mirror prohibited transaction rules under the Internal Revenue Code. As a result of these prohibitions, it is unlawful for a fiduciary to earn commissions or any other type of variable compensation that varies based on the particular investment that is recommended to a client. Therefore, an advisor would only be permitted to earn variable compensation if it were able to qualify for an available exemption from the prohibited transaction rules. Thus, if a broker or insurance agent were deemed to be a fiduciary to a plan or an IRA client under the newly proposed rule, in order to earn commissions, it would need to qualify for an exemption. To address this regulatory need, the DOL has proposed the best interest class exemption. The best interest class exemption, which I am going to refer to as the BIC exemption for short, is designed to provide relief to fiduciary advisors who earn variable commissions from retail retirement clients. The covered retirement clients include participants and IRA owners. They also include sponsors of non-participant directed plans with less than 100 participants, such as small defined benefit pension plans. Now, as you may have just noticed, there is a glaring omission from this list of covered retirement clients under the BIC exemption. The BIC exemption is supposed to cover retail retirement clients, yet it fails to include sponsors of small 401k plans and other plans with participant-directed investments. The DOL is requesting comments from the public on whether it should extend the BIC exemption to small participant-directed plans. Presumably, the industry will push for this relief. However, if this relief is not ultimately proposed and granted by the DOL, brokers and insurance agents may be unable to earn commissions when selling investments to small 401k plan sponsors once the DOL fiduciary rule is finalized. It should be noted that the DOL does not contemplate providing any relief for brokers and insurance agents serving large plans. Without any exemptive relief, these advisors would no longer be able to earn commission-based compensation from any defined benefit or defined contribution plan with 100 or more participants. They say the devil is in the details, and that is also true in the case of the BIC exemption. The exemptive relief under this proposed exemption is specifically restricted to certain listed investment products. This includes bank deposits and CDs, mutual funds, exchange-traded funds, bank collective investment funds, and insurance company separate accounts. They also include exchange-traded REITs, as well as corporate bonds available under registered offerings and equity securities that are publicly traded. Treasury and agency debt securities are also covered, in addition to insurance and annuity contracts, as well as GICs or guaranteed investment contracts. Now, if you take a close look at this list, you will notice that privately placed debt securities, non-traded REITs, and alternative investments are omitted. Thus, if the DOL proposal, including the BIC exemption, were finalized in its current form, it is possible that brokers would no longer be able to earn commissions by selling these types of investments to their IRA and plan clients. Since this would have a significant impact on broker-dealers, we can expect the applicable trade groups to weigh in on this aspect of the DOL proposal. One of the central requirements of the BIC exemption is a written agreement between the fiduciary advisor and the retirement client. The agreement must contain certain mandatory provisions and warranties. First, under the terms of the agreement, the advisor must acknowledge that it is a fiduciary for purposes of ERISA and the Internal Revenue Code as applicable with respect to the advice that is being provided. Second, the agreement must incorporate the impartial conduct standard as defined under the BIC exemption. This means that the agreement must provide that the advice will be provided by the advisor in accordance with the best interest fiduciary standard, which is similar to the prudent man standard of care under ERISA. The agreement must also provide that the advisor will only earn reasonable compensation and that no misleading statements will be made. Third, the agreement must include various warranties from the advisor. The advisor must warrant that it will comply with all federal and state laws. It must also warrant that the firm has adopted compliance policies reasonably designed to mitigate conflicts of interest and that it has eliminated any incentive that would encourage the advisor to make recommendations that are inconsistent with the best interest fiduciary standard. Lastly, the agreement must not limit the advisor's liability for contract violations. The agreement may contain an arbitration clause as long as there's no waiver of the client's right to participate in a class action lawsuit. To comply with the BIC exemption, certain disclosures must be made to the retirement client. The written contract must contain 4 disclosure items. It must identify the advisor's conflicts of interest, which would presumably include the fact that the advisor can influence its own variable compensation. It must disclose the client's right to obtain fee information from the advisor. It must indicate whether the advisor offers proprietary products or receives third-party compensation, such as revenue sharing. It must also include the address of the advisor's web page, disclosing all relevant compensation. In addition to including disclosures in the written contract, the advisor must also provide certain transaction disclosures. An upfront disclosure that includes a chart displaying the cost of making the recommended investment for 1, 5, and 10-year periods must be made. In its proposal, the DOL has included a model chart, although its usage is not mandatory. Annual disclosures of all investment and fee activity during the relevant period must also be provided to the retirement client. The advisor must also maintain a web page with disclosure of compensation from all investments held by the client during the preceding 365-day period. In general, to satisfy the BIC exemption, the advisor must offer a broad range of investments covering all reasonably necessary asset classes for the retirement client. However, the advisor is permitted to offer a more limited range of investments if certain conditions are met. The firm must make a written finding that the range limitations do not interfere with the best interest fiduciary standard for providing advice. The advisor must receive reasonable compensation only for its services, and written notice must be provided in advance to the retirement client describing the range of limitations. The advisor must also notify the retirement client if the advisor does not recommend a sufficiently broad range of investments to meet the client's needs. The DOL contemplates that an advisor may have range limitations because the firm, in certain circumstances, may limit its investment offerings to proprietary products or investments for which the firm receives third-party payments or revenue sharing. The BIC exemption does involve a regulatory filing. Under the proposed exemption, A one-time notice must be filed with the Department of Labor before a firm may receive any penny of variable compensation based on the proposed relief. The notice does not need to identify the firm's plan clients or the firm's IRA clients. This notice filing with the DOL does not need to be approved by the DOL. Accordingly, there is no substantive approval process or waiting period once the notice is filed. We mentioned earlier that when an advisor earns variable compensation, exemptive relief is necessary from the prohibitions against fiduciary self-dealing under ERISA Section 406B and the mirror provisions under the Internal Revenue Code. Separate exemptive relief is necessary for transactions with a party in interest under ERISA Section 406A and the corresponding code provisions. For example, an insurance company that provides administrative or TPA services or any other service to a plan or IRA client is a party in interest with respect to such client. An exemption is necessary if the retirement client is then interested in purchasing an insurance or annuity contract from the insurance company because of its status as a party in interest. The proposed BIC exemption offers relief for these types of purchases. The conditions are fairly straightforward. The insurance or annuity contract purchase must be in the ordinary course of business for the insurance company. The insurer must receive only reasonable compensation, and the purchase must be cash only, not in kind, and of course, the terms must be at least as favorable as those that would be found in an arm's length transaction. Now, I have some observations on this BIC exemption. The BIC exemption is truly an interesting piece of rulemaking. As a technical matter, the DOL is responsible for defining what a fiduciary is for both plans and IRAs, and is also responsible for granting exemptions for both plans and IRAs. However, the IRS generally has exclusive enforcement jurisdiction over IRAs. If an advisor were to violate its fiduciary duties to an IRA client, the DOL would have no enforcement power over the advisor. In recognition of this fact, the BIC exemption effectively gives IRA owners the contractual power to enforce any fiduciary violations made by an advisor. By requiring the inclusion of the impartial conduct standard in written contracts, the DOL has effectively handed off its enforcement responsibilities to retail investors and to the plaintiff or tort bar. I also wanted to highlight the fact that the BIC exemption as proposed is going to have a huge impact on brokers and on insurance agents. Even if you don't have any plan clients, the BIC exemption will still affect advisors with any personal clients with IRA money. Complying with a BIC exemption may be a difficult undertaking for broker-dealers and insurance agencies. The required disclosures may be somewhat burdensome, but I suspect that they will find it especially difficult to eliminate all incentives that encourage so-called improper advice as required under the exemption. It will be interesting to see how the industry responds and comments to the DOL proposal. In addition to the BIC exemption, the DOL proposal includes one other new exemption from the prohibited transaction rules under ERISA and the Internal Revenue Code. It is referred to as the Principal Transactions Exemption. The Principal Transactions Exemption is intended to address the fact that broker-dealers may be viewed as fiduciary advisors with respect to their plan clients and IRA clients. Although the BIC exemption would provide relief for a fiduciary advisor providing brokerage services for commission-based compensation, the BIC exemption would not cover the sales of securities from the broker-dealer's inventory, which would be viewed as a principal transaction between the broker-dealer and the retirement client. The conditions for the principal transaction exemption are actually fairly similar to those under the BIC exemption. For example, it includes contract requirements that mirror those under the BIC exemption. In terms of its product scope, the principal transaction exemption only covers the purchase and the sale of certain types of debt securities. Specifically, it covers U.S. corporate bonds available under registered offerings as well as Treasury and agency debt securities. Thus, it does not cover private placements of debt securities, equity securities, or alternative investments. So, the bottom line in general is that broker-dealers can sell debt, not equity, from inventory in the small marketplace. But note, there's full relief to sell both in the larger plan marketplace pursuant to the counterparty carve-out that I referenced before. Broker-dealers need to be very mindful of these distinctions. As part of its fiduciary proposal, the DOL has also proposed amending several existing exemptions. In general, the DOL is incorporating the impartial conduct standard and proposing other related changes to these exemptions. The affected exemptions are highly technical in nature, and discussing the proposed amendments would first require us to do a deep dive into what these various exemptions do. That is beyond the scope of today's webinar. But so you have a feel for what changes are being proposed, I have listed the applicable exemptions here. In connection with its fiduciary proposal, the DOL has asked for comments on whether it should establish a low-fee exemption. This exemption would be similar to the BIC exemption in that it would permit a fiduciary advisor to earn variable compensation. However, it would have fewer requirements than the BIC exemption, and it would address scenarios in which the advisor recommends the lowest fee product in a given product class. The DOL released its fiduciary proposal on April 20th. The 75-day notice and comment period for the public ends on July 6th. The DOL has announced it will schedule a public hearing within 30 days after the end of the notice and comment period. After a transcript of the hearing is released, the public record will be reopened for comment. Once the proposal is finalized, the DOL has indicated that there will be a delayed application date. The final rule will not become legally effective until 60 days after its publication. However, requirements under the final rule generally will not be applicable until 8 months after publication. The intent is for firms to be given sufficient time to adopt any required policies and prepare the necessary disclosures as required under the applicable exemptions, including, but not limited to, the BIC exemption. When it comes to politics, you can never be 100% certain of what is going to happen. But the current administration has made it clear that the DOL fiduciary proposal is a priority, and the White House has promoted it heavily. And we can be certain that the administration will do everything within its power to get the proposal finalized before the end of its second term, which goes through January of 2017. The SEC has indicated that it will consider establishing a uniform fiduciary standard that would apply to both investment advisors and brokers. However, based on my reading of the tea leaves, it appears unlikely that Congress will be able to delay the finalization of the DOL proposal by forcing the DOL to coordinate its rulemaking with the SEC. The DOL has gone on record as stating that it is already coordinating its rulemaking efforts with the SEC, and, as I said, the DOL has the full support of the White House behind it. Even if Congress were able to pass legislation designed to slow down the DOL's efforts, the President would have the power to veto it. We covered a lot of detail today, but I hope you're able to see the big picture policy goals that are driving this rulemaking effort. In the end, the DOL is seeking to impose a best interest fiduciary standard on all types of advisors to plan sponsors, participants, and IRA owners. Rather than coming up with a detailed rules-based exemption, the BIC exemption follows a principle-based approach that is remarkably similar to the existing legal framework for regulating investment advisors, requiring heavy disclosures and the adoption of compliance policies, protocols, and procedures. If the DOL is successful and the proposal is finalized and close to its current form, there will be a new regime that effectively creates two classes of fiduciary advisors, those earning variable compensation and those that do not. With regard to fiduciary advisors earning variable compensation, the conflict may be mitigated, but it would not be wholly eliminated. And a lot of retirement clients may not realize that fiduciary advisors can still earn variable compensation. We would have a universal fiduciary standard for all types of retirement advisors with the BIC exemption for small, non-participant directed plans, IRAs, and participants. Before we wrap up, I just wanted to take a minute to talk about the expected impact on advisors. The DOL proposal would affect substantially all advisors, even if they don't have plan clients, because of the proposal's reach to IRA assets. This is why so many people are referring to this rule as a game changer. Advisors who have nothing to do with plan assets, but who do have high net worth clients with IRA money, are going to be profoundly impacted by this rule change. On a related note, the DOL proposal is also going to impose significant compliance costs on broker-dealers and insurance agencies as a result of the requirements imposed under the BIC exemption. It appears that the required disclosures under the BIC exemption would be significantly more expansive than those under the current 408(b)(2) fee disclosure rules. For example, conflicts of interest do not need to be disclosed under the 408(b)(2) disclosure rules, but these and other disclosures would be required under the BIC exemption. Presumably, the DOL fiduciary will have a minimal impact on RIAs, although it may cause some advisors to consider joining or becoming RIAs to avoid the compliance burdens associated with the BIC exemption. In terms of next steps for advisors and plan sponsors, given the far-reaching impact of the DOL proposal, it is critical for stakeholders to stay abreast of the rulemaking process and to consult ERISA counsel. Advisors may wish to re-examine their client service models and documentation, including 408(b)(2) disclosures and service agreements. Similarly, plan sponsors may wish to confirm the fiduciary status of their advisors as well as the scope and the nature of their investment responsibilities. Sponsors should also check in with their advisors to determine the extent to which the DOL's new fiduciary rule is going to impact the advisor service or fees. And with this, I conclude today's webinar on the newly proposed DOL fiduciary rule, and I thank you.
Thank you, Marcia. That was really informative, and thank you everyone for attending this webinar. We will be doing additional programs on this topic as the law develops. A recording of this program will be available shortly on the Wagner Law Group website, and please do not hesitate to contact Marcia if you have any questions. Marcia's email address is Marcia, spelled M-A-R-C-I-A, @wagnerlawgroup.com. Thank you very much.